Thank you, Margaret. Good afternoon, everybody. The 2020 Programme for Government under the heading of Courts Reform has indicated an intention to establish a new planning and environmental law court managed by specialist judges on the same basis as the existing commercial court model. The setting up of a specialist environmental court is not new. It was advocated by former Chief Justice Susan Denham as far back as 2012 in the course of her marking the 75th anniversary of the enactment of the Constitution. It appears that various states in Europe and elsewhere have already made provision for the setting up and operation of specialist environmental courts. For instance, there exists a specialist land and environmental court in New South Wales in Australia, and a similar court or tribunal in Sweden, which include judges as well as technical experts. The environmental tribunal has been set up in the UK, and the High Court list in England and Wales includes a planning court, which operates as a discrete specialist court as part of the ordinary High Court listing system. These types of court arrangements represent different scales on the spectrum of what different court systems operate in regard to the provision of specialist planning and environmental courts. On the one hand, there is a one-stop shop court, which includes members of the judiciary working alongside technical experts. Whereas on the other side of the spectrum, the existing court system operates a planning and environmental court as part of its lists, and which is comprised of members of the judiciary who have experience in dealing with planning and environmental cases. These contrasting approaches have been characterized as involving either a big bang approach or a more measured policy that works within existing court systems and adapting them to the evolving environmental climate. Now, one of the criticisms of the present system has been that judges who don't have the expertise are in some way less efficient or less expert in dealing with planning and environmental cases coming from a generalist background. Another point that's raised is that the current restrictions in judicial review here in Ireland and also in the UK are too limited in that they fail to provide for a complete oversight of administrative decisions under challenge. The point that fairly can be made in relation to the first of those points is that it fails to recognise that every day of the week, members of the judiciary are weighing up evidence given by competing medical experts in personal injury cases, including medical negligence cases, and also dealing with competing expert engineers' evidence, dealing with property damage cases, or accountancy experts in commercial disputes. And the system works. Now, is there a case to be made for judges with a background as practitioners or as judges who are familiar with planning and environmental cases? Yes, of course. They can provide an extra level of efficiency above and beyond a generalist judge with a generalist background. The criticism in relation to the restrictions in judicial reviews can be countered as follows. Local authorities and on board Penola have the necessary expertise in their employment, and that expertise is applied in the making of the administrative decision and informs the makers of the administrative decisions that decide whether or not development consent for a particular development shall be granted, and if or not, and if so, the conditions upon which the development will be allowed to proceed. That leaves the High Court to deal with the rationality and the lawfulness of that decision, where the expertise is loaded up front as part of the administrative process leading to the decision making in regard to applications for development consent. How is enforcement of the planning code or breaches of environmental laws operated in Ireland? In Ireland, the current system of enforcement of planning and environmental laws and review of development consents operates as follows. Breaches of the planning code are prosecuted generally by local planning authorities, normally by summary prosecution in the district court. Less frequently, the local authority will pass on the baton, so to speak, to the Director of Public Prosecutions in respect of prosecutions on indictment that would involve a jury trial. The Planning Code provides for the granting of injunctive relief to restrain breaches of the Planning Code. Section 160 provides for the bringing of such applications in the Circuit Court, where the value of the land does not exceed the amount of €3 million, or an open jurisdiction in the High Court. The waste management legislation also provides for similar measures for the granting of injunctive reliefs for breaches of the Waste Management Code. The High Court has jurisdiction to grant judicial review in proceedings challenging the validity of planning permissions and other statutory administrative decisions. To appeal a High Court judgment in a judicial review of a planning decision, the High Court must grant a certificate for leave to appeal to the Court of Appeal on the basis that its decision involves a point of law of exceptional public importance, which arises from the court decision itself, and that it's in the public interest to do so. How are our lists operated at present? Currently in the High Court, there is a special list which deals with planning matters, judicial review matters, which are brought initially, or would have been brought initially, into the commercial list. And also it deals with challenges to decisions made under the Strategic Infrastructure Development System. These are Board Penola decisions. Planning decisions, for which are the subject of judicial review and which are part of the commercial court, or would have been part of the commercial court list, involve disputes where the amount in dispute is over €1 million. That would reflect the value of the property, which is the subject matter of the judicial review proceedings. Strategic infrastructure development, by its nature, involves substantial development, and that's sometimes referred to for short as the SID list. The commercial court planning list and SID list are combined and are dealt with by a particular judge who operates with procedures and practice directions quite similar to the procedures which have been operating in the commercial court in respect of commercial disputes. Other judicial review cases in relation to ordinary planning decisions, that's to say that falls outside the SID list and outside the commercial planning list, they are dealt with in the ordinary judicial review list and are dealt with accordingly by the assignment of judges in the non-jury list. That means that they are part of the same confluence of judicial review cases that deal with prosecutions and that deal with challenges to decisions in courts of local and limited jurisdiction in criminal cases, and challenges also to statutory administrative body decisions other than planning and environmental decisions and so on. There is a case, I believe, that ordinary judicial review cases concerning planning decisions ought to be brought into the same list that deals with the commercial planning judicial review cases and also the strategic infrastructure development cases. The planning and environmental court should not be confined only to major projects. Hazards to the environment can arise from smaller developments just as easily as major projects. Now, what is needed in relation to the judicial the list, the commercial and the commercial court model at this stage is that there should be a list put in place which will provide for judges with a background either as practitioners or as judges in dealing with court cases concerning planning and environmental judicial reviews and enforcement type decisions. It makes sense that enforcement cases, that's High Court cases dealing with Section 160 injunctive relief, should also be in the list and not just judicial review cases. The commercial court model, which has been operated very successfully since its inception, provided a mechanism whereby parties were assured of an early date in respect of a hearing in that court, and also that a judge would be available, the case would proceed and wouldn't be adjourned, and there was a streamlining of practice and procedure to ensure that the case moved smoothly towards a hearing and an early determination. That model is, to an extent, invoked already in the commercial court planning list and in the SID list, and it makes sense that other planning cases, both by way of judicial review and High Court enforcement proceedings, also pass through that list. Obviously, as there's only one judge in charge of that list, it will be necessary for the President of the High Court to provide the resources by way of extra judges to hear cases in that list to follow the proposed government court reform in this area. Constitutional considerations. Going back to the suggestion in various parts of the world that a specialized environmental court should be set up to meet the needs of the community, it is difficult to envisage in this state the setting up of an autonomous standalone environmental court which operates as an extra layer which is separate from the rest of the existing court system without substantial amendment of the Constitution. This issue was addressed by Mr. Justice Clark, as he then was, in 2015, in an article which he wrote in the Irish Planning and Environmental Law Journal, where he noted that Article 34.3.1 of the Constitution defines the High Court as a court with full original jurisdiction, quote, on all matters and questions, whether of law or of fact, civil or criminal, close quote. In that article, Mr. Justice Clark queried whether the Oireachtas has the competence to confer an exclusive first instance jurisdiction on a court other than the High Court. And on that basis, and on the basis of the judgment of the Supreme Court in Tormey v. Ireland, which held that jurisdiction could be conferred on, quote, so-called courts of local and limited jurisdiction, which was capable of being exercised, at least in certain circumstances, to the exclusion of the High Court, close quote. However, he also noted, quote, there have been some suggestions that the fact that the High Court has a constitutional status as a court with full original jurisdiction must imply that such legislation could not, however, legitimately exclude an oversight or review role of the High Court, close the quote. Accordingly, if a specialized environmental court is subject to possible High Court judicial review of its decisions, it would appear that the insertion of such an extra layer into our court system for environmental law cases would defeat the purpose of the agenda in seeking to have such cases heard and determined with an extra degree of expedition. Now, the specialists that are operating at present could be augmented, to, as I suggested a moment ago, to include also Section 160 proceedings and ordinary planning judicial reviews. That's to say, judicial reviews which are not part of the commercial planning court thresholds. In other words, they would involve developments which are something less than $1 million in value. And in that sense, it's simply a matter of extra resources. The expertise, I believe, is there. Now, what about the circuit court? Planning and waste management enforcement proceedings seeking injunctive relief can be brought in the circuit court where the value of the land in question, which is the subject of the proceedings, does not exceed €3 million in value. Many of these cases are likely to have a possible hearing duration which impedes a circuit court judge from having the capacity to deal with such cases as efficiently as might be possible if the cases were listed in the High Court. It may be possible for the Circuit Court to organise a Circuit Court judge or judges with experience in planning and environmental cases to travel from circuit to circuit to provide backup for the non-Dublin Circuit judges who are already dealing with severely congested lists. However, such cases are open to a full appeal in the High Court, and again it may be that such an appeal might also have to be considered for inclusion in the planning and environmental list in the High Court. Ireland is a party to the 1998 UNECE Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters, generally referred to as the Aarhus Convention. The third pillar of the Aarhus Convention concerns access to justice and gives rights to members of the public as well as non-government organisations to challenge the legality of decisions by public authorities, as well as other acts or omissions of national laws relating to the environment. Article 9, sub-article 4 of the Convention requires that procedures be, quote, fair, equitable, timely, and not prohibitively expensive. I believe that no issues realistically arise regarding the fairness and equitable nature of proceedings operating before our independent judiciary. And this proposed court reform will facilitate the obtaining of a hearing and determination in planning and environmental cases in a more timely manner. The provisions of Section 50B of the Planning Code greatly restrict costs orders being made against parties seeking judicial review challenges in respect of planning permissions where environmental issues arise. That factor, and also a court-led flexibility on questions of standing or capacity of applicants seeking judicial review in planning and environmental cases, appear to indicate that the new planning and environmental division of the existing High Court lists can meet the requirements of Article 9, sub-article 4 of the Aarhus Convention. I was a long-standing practitioner engaged in planning and environmental cases. I believe this proposed reform, which will provide for the setting up and operation of a new planning and environmental court on the basis of the existing model of the commercial court as part of the High Court, is a reform which is to be welcomed. That concludes my presentation. Thank you, Margaret.